Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today we have a breaking news update on the Ripple XRP lawsuit. Yes, ladies and gentlemen, I am not kidding when I say that there is some interesting turn of events. We got two pieces today. First of all, we got the Ripple response. Let's actually read it fully. We got Ripple filed its memorandum of law in opposition to the SEC News motion to strike Ripple's lack of due process and fair notice defense. See below. And that's basically one little document. I actually tried to buy this sealed exhibit here a little bit earlier, but the problem was, right, I saw it instantly when it came out. It was during the live stream. You have to be a lawyer in the United States, though, to actually purchase it, which is a little bit of a bummer. We've actually been refreshing this court listener like crazy as well, but I think that James has some type of inside connection or something like that, because he posted these documents within minutes or even before they were posted on here. Because I've been refreshing court listener like crazy. And I think refreshed it like 5 minutes ago, and he posted it 17 minutes ago, which means this guy has some different source to get his information. Now, the whole seal ordeal, which is basically the bottom part here, nobody cares about that. It's not interesting that, anything like that. This top part is what people are interested in, and I guess he bought it, or at least he got it in some other way, shape, or form. And again, in essence, what it is basically Ripple replied to the SEC, where the SEC stated that Ripple had a defense, and one of those defenses was called the lack of fair notice and affirmative defense, or and due process affirmative defense, something like that. And it basically means they think, Ripple, that the SEC should have given a heads up before suing. They basically should have told exchanges, hey, what you're doing here is not correct. Or they basically should have told anybody who asked, hey, no, don't work with XRP because it's bad, and they didn't do that. So they are using that as a defense that Ripple could not have known either that it was a security, basically. And the SEC said, well, we don't think that's a good defense. We don't think that that's going to actually win you this lawsuit. And now Ripple can respond. And that's basically what they did. Arguments: Ripple has pleaded a tenable legal defense that it lacked fair notice and can demonstrate that there are disputed or substantial issues of law. That is 3 points. Ripple has sufficiently pleaded an affirmative defense under Upton. Wyndham does not support SEC's motion to strike, and the SEC's remaining arguments fail. That one is, I guess, the most interesting, over at page 15. Then Ripple's answer alleges sufficient facts to support its fair notice defense, and SEC's contrary claims cannot be resolved in a motion to strike or on a motion to strike. The Prosper order did not provide fair notice. The 2012 legal memoranda did not provide fair notice. The SEC's guidance did not provide fair notice. The FinCEN's and DOJ's settlement did not provide fair notice, and the SEC's investigation did not provide fair notice. The SEC is not prejudiced by the inclusion of Ripple's fair notice defense, and basically it's once more Ripple explaining why they are juicy and why they think that they are, in their right, basically, to defend themselves. So if you want to read this for yourself, I've retweeted it now, once more over on Twitter, obviously, and take it from me that this bottom part is not going to be too interesting. A seal is just always trying to lock up some documents, and I don't really care about that at all, to be honest. Again, we're not going to know exactly why they're trying to seal some stuff or exactly how that all works, so why bother yourself with it? It's not worth your time. These ones are more interesting because, again, it is Ripple going against the SEC explaining why they are wrong, and again, why Ripple thinks that they should basically keep this defense. Again, guys, what it basically means is Ripple has a defense right now. The SEC wants to throw it out. Ripple says, no, we think it's relevant for this case. And if the judge agrees that the the defense is somewhat relevant to the case, it cannot be thrown out. It is only if the judge really doesn't think either that it's relevant to the case at all that it can be thrown out. So let's quickly read here. The SEC attempts to reframe Ripple's affirmative defense as a void for vagueness challenge, which it then argues fail as a matter of law. As noted above, Ripple's defense is based on the Second Circuit's Upton decision, which never uses the word vagueness at all. But even if the defense were considered as an as-applied void for vagueness challenge, the SEC still cannot show that Ripple has failed to assert a legally cognizable defense. By the way, guys, if you are enjoying the daily crypto videos, make sure you help the channel out by pressing the subscribe button and like button. The subscribe you're doing for you because I post daily crypto updates, and I will always post this stuff as soon as I have it available. And also, guys, of course, the like button just helps out with the YouTube algorithm a little bit, so why not support it if you can? And my question of today is, do you think I've just woken up, or do you think I haven't slept just quite yet? Let me tell you, it is very light outside. Yeah, it's very light outside. Let's put it like that. The SEC cites a handful of cases that rejected as applied void for vagueness challenges to the term investment contract in the Securities Act. It ignores the critical point that in this case, unlike the case it cites, XRP is neither an investment contract nor actually a contract. So basically, it's not an investment nor a contract. See answer prelim statement 14. In each of these cases cited by the SEC, the selling party made contractual offers coupled with promises of future investment returns, conduct that fits within the heartland of the concept of an investment contract. Here, Ripple has alleged in its answer, Ripple has never explicitly or implicitly promised profits to any XRP holder and has no relationship at all, contractual or otherwise, with the vast majority of XRP holders today, nearly all of whom purchased XRP from third parties on the open market. And what limited contracts Ripple did enter into with sophisticated institutional counterparties were not investment contracts, but standard purchase and sale agreements with no promise of efforts at all by Ripple or future profits. Ripple will prove this through evidence gathered in discovery. That's actually really cool to see. And for the present motion, the court must accept Ripple's allegations as true. That's just, in this specific case here, what I've noticed throughout all these court cases is that this is basically assumed to be true to base the rest on. So if it's later debunked to be fake, that is all fine, but they're assuming it's true and then utilizing that to kind of see the rest. And that's also with some of these other arguments, some of these motions that they're putting out. With a lot of these motions, they basically allege, okay, what if all of those points were to be true? Would it then be relevant? And if that's the case, if all those points were to be true and it's still not relevant, then a certain piece can be thrown out, for example. That's actually something they used a couple of times before. Now, Ripple will prove this. The SEC likewise suggests that Ripple's fair notice defense is an equitable defense, again arguing that it is precluded as a matter of law. The court can swiftly reject this argument. Fair notice is a legal defense based on the constitutional due process interests, and Upton says nothing about equity. Indeed, the SEC concedes, as it must, that Ripple has never claimed to be asserting an equitable defense. In any event, Ripple's defense is not equitable in nature. Ripple's defense is not that the SEC has unclean hands or that it has slept on its rights. Its defense is that the SEC failed to provide the public with the required fair notice that assets with the characteristics of XRP would be considered investment contracts. There's no bar to raising such a defense against the government agencies. If there were, Upton would have affirmed the SEC's sanction order rather than vacating it. So the only problem is I actually just posted a video like a little bit ago, so I'm gonna have to wait like an hour or so before, no, maybe like 2 hours even, before I can actually upload this video or publish it at least. I also have a little bit of minor editing to do at one point here because I just kind of want to do that. But that might mean it so you have to wait another hour or so for this information to come out. Then again, this is really kind of bullish on a shorter type of term. I mean, it's not a huge announcement or anything like that for XRP. It's just nice, right? Because this, again, Ripple showing why they are right in most of all of this. In the end, guys, I keep telling you I am buying XRP. I've told quite a lot of people in my time that I think buying XRP is a good thing. But then again, mind you, very much so. I don't necessarily say, hey, go buy it right now. Why? Because I always think it's kind of stupid if you tell somebody to buy something and it turns out to be bad. I would rather them ask me questions and I can answer them about investments and we can kind of both grow from that instead of them asking me a recommendation for crypto and them hating me for the rest of their life for it, right? I would rather them have me ask information about a crypto and then decide themselves if they want to buy. I never give financial advice, as you guys most likely know already, but also I think it's kind of scary to tell people to go do that type of stuff. It's pretty funny that it's on a bill like that, though, even though he could have drawn it on later, who knows. Then a lot of people in Discord were talking just now. I was in Discord for a couple of hours, no, a couple of minutes, I guess an hour or so, maybe 30 minutes, 45, earlier today, and we were discussing XRP market cap. XRP on CoinMarketCap here is the number 7/number 8. It's been, number 7, I guess. Yeah, it's definitely not even close to any of those other ones. It's number 7 for a little while, mostly because CoinMarketCap decided to take off a lot of those coins off the market cap for some reason. I think about 11 billion coins have been taken off, and the actual number is here. It should have been 46, and they're using the top number here, which is 35. Why? We don't know, and they're still not fixing it, which I think is a pretty big issue. Then again, guys, let it be. Right? If they don't want to go for it, okay. It's misinforming a lot of people, but it also shows the reputation that they want to go for. Binance owns CoinMarketCap. Do not forget that. and eventually all this shit will come to light. It's a waiting game, but it will be fine, guys. And that was it for today's video. Just a quick little update. If you want to trade XRP or crypto or anything like that, make sure you use the link down below for Bybit is the one I am using. And there are a couple of XRP bonuses, as you most likely know already. There's also, of course, this newer pool and bonus for using XRP versus the US dollar instead of coin margin, whatever. Use the link down below. Go check it out. And I'll see you guys again in another crypto video. I'm just doing this to make it as quick as possible.